Hello and welcome to the program. I am Deji Badimosi. Almost 3 years into his second term as Ebonyi State Governor and currently nursing a presidential ambition, the tide now seems to be turning for Governor David Umahi, turning against him as a matter of fact, as he is currently locked in a legal battle to retain his governorship seat. Earlier in the week, a federal high court judge in Abuja sacked Umahi, his deputy Eric Igwe, and 16 other lawmakers for defecting from the People's Democratic Party, under which they contested election to the All Progressives Congress APC. Now, Justice Inyang Ekpo rules that the votes that they all got during the election belong to the party and not the candidates. And so what that literally means is that because they have left the PDP can then take back the votes and pass them on to any other person it deems fit. That's quite strange if you ask me, but that is simply what the judge said. He also dismissed the argument that the governor and the deputy governor enjoy immunity, adding that the provision of the Constitution does not apply in the current situation. He therefore ordered INEC to receive now from the PDP names of persons to replace Umahi and his deputy, or in the alternative, conduct fresh gubernatorial election in Ebonyi State. Now, that's a bit confusing because it simply means INEC will have to decide whether, well, it simply wants to receive names forwarded to it by the PDP and go ahead to issue them now with certificates of return or conduct another gubernatorial election. That's somewhat strange. Well, Governor Umahi and his lawyers have faulted the verdict and they have filed an appeal against it. Nonetheless, the verdict has been a big talking point in the country, and one fundamental question arising from it is who exactly owns the votes scored in any election? Do the votes exclusively belong to the political parties, and so they can do as they please now with the votes? They can actually transfer the votes to another person in the event a governor, for instance, defects to another political party? Well, joining me to discuss all of this is Libros Oshoma, who is a legal practitioner. Libros, thank you very much for joining us on the program. Now, this is another new verdict, if you ask me. It's something we've actually not seen before, and so this is actually it's actually coming for the first time. Just give me your take on the ruling of the judge.
Yeah, thank you, Deji. The issues are multifaceted. They are what you would call legal hydra-headed issues. And then it will be difficult for you to pigeonhole them all in one jacket. Like the one you raised of INEC receiving names from the PDP to replace the name of the governor. That's also one, first and foremost, it's a legal impossibility. Because by virtue of Section 140 of the Electoral Act, if you remember, which was amended after the Supreme Court judgment in Amechi and Umahi and Omehia, that you cannot be declared a winner if you did not participate in all the phases of the election.
Yes.
So in that, by virtue of that section, you cannot inherit a victory like it was done in Amechi's case.
So does it mean the judge is not aware of that amendment? I can't understand it.
That is why the judge gave prayers in the alternative, two prayers that are conflicting. One, contradictory. In one breath, he says, look, receive names. In another breath, he says, conduct an election. So he knows, he's aware. And then secondly, the Supreme Court, in starting from Amechi's case, and then subsequently in Yaya Bello's case, Ifaleke and Yaya Bello's case, held that the votes actually belongs to the party. Because the party is the party's name that is on the ballot and not the name of the candidates. So that's on one end too. And that's why I said all of the issues are conflicting. And then lastly, by virtue of Section 1888 of the Constitution, it clearly spells out how a governor can be removed from office, either by resignation, death, or through impeachment. There is no other provision in the Constitution that requests or empowers the state high court to remove a governor from office having defected. In the same vein, there is no provision in the Constitution that also empowers a governor to, having been elected on the platform of a political party, to defect to another party. That is covered for the legislature. The provisions are well spelled out in Section 68 and Section 109 of the Constitution. But for the governor, the deputy governor, the president, and the vice president, the Constitution is silent on whether they can defect or not. And so that's why there is a lacuna. What I think is happening here is that there is a lacuna. No matter how sweet or how good the judgment is to stem the tide of this incessant jobology, but it really has no basis in our law books.
Now, what I find difficult to understand, Libros, and I'd want you to educate us more on that. I mean, the legal aspect of this. You know, you just said because a lot of people have been citing the case of Amechi versus Umahi. They've been citing that to justify the judgment of this judge. Tell us in plain terms, legally speaking, does this really apply in this case? And you've just confirmed that that even after that judgment was given, we know at some point the National Assembly had gone ahead to amend some sections of the Constitution and the Electoral Act pertaining, especially the ones now that actually affect that judgment, if you like.
The two scenarios are not the same. One is a post-election matter, pre- and post-election matter. Why this is not a pre- or post-election matter? It's an issue of defection. And like I said, once a governor is sworn into office, he can only be removed from office by the virtue of the provisions of Section 188 of the Constitution, or by death, or by resignation. And so in the case of Amechi and Umahi, what the court was determining was illegal substitution. Whether after a candidate had been validly nominated, whether that candidate can be illegally substituted, or whether that candidate can be substituted by the party. And the court in its wisdom said, no, once that candidate has been validly nominated, he can no longer be substituted. The court was not saddled with the responsibility of determining whether a governor who was elected on a platform and had been sworn in can be removed from office because he has defected, to now determine where votes belong or where votes does not belong. And so the court in its wisdom in determining Amechi and Umahi's case now went further to state that since the votes originally belonged to the party, then you can no longer ask the INEC to go conduct another election. So since this candidate, the presumption of the law is that the candidate in the eye of the law was never substituted. So since the substitution was illegal, so in the eye of the law, the candidate, which is Amechi, was never substituted. And so the vote that accrues to PDP belongs to him. So that was what happened in that case. But in this case here, what is playing out here now is this: Umahi has been sworn in as a governor. He has taken oath of office. What is in dispute is not whether Umahi validly won the election or that PDP validly won an election to determining swearing in or not swearing in. What is in dispute here is that there is no constitutional provision, like I had said, empowering Umahi to defect from the political party, having been voted on the platform of that party, to another party. And also, there is no constitutional provision prescribing any punishment or action or acts that should happen after you defect. So what people are just doing, what lawyers are basically just doing, it's all, like lawyers will always do. It's all conjectures, ideas and counter ideas on what should be. If you look at, there is no constitutional provision also under either the Federal High Court rules or even in the Constitution that empowers the Federal High Court to determine a question of when a governor defects from one party to another, that or donate jurisdiction to the Federal High Court to determine, who owns what should happen when a governor defects from one political party to another, having been sworn into office. Also,
another thing I want to... Okay, go ahead.
Quickly, that should have been an issue of jurisdiction. The jurisdiction of the Federal High Court to so determine. The Federal High Court does not have such power to so determine. And I am happy that the governor had appealed the decision instead of all of those grandstanding, talking like a layman. And, I didn't expect those kind of talk from somebody at that level. If you disagree with a judgment of the court, I must say this. If you disagree with a judgment of the court, there are channels for ventilating your disagreement. Instead of all of those resort to gutter languages and throwing that trap at the judge. That is the judge's opinion on the basis of what he had said. Let the Court of Appeal determine. And then subsequently, let us have the benefit. For once, let us have the benefit of the Supreme Court also determining, this matter so that we can rest it one way or the other. Because in the case of Atiku, a lot of people also have cited Atiku, Attorney General and Atiku. What happened in that case, if you remember, was Atiku defected from PDP to ACN.
And Obasanjo declared his seat vacant.
And Obasanjo, using the Attorney General, not the court this time, Obasanjo did not approach the court. Using the Attorney General, declared his seat vacant. And Atiku went to court, and the court said, no, that is not one of the ways to declare the seat of a sitting vice president vacant. And also, it is not provided for in our laws that once a sitting vice president leaves his seat, having been voted on the platform of a political party and moved to another party, that there is no provision in our law on what should happen to him. So against that backdrop, I had expected that when the 5 governors of PDP defected to APC, then at the formation of APC, that would have been an opportunity for the Supreme Court to actually determine, what should happen with this defection back and forth. But that case was warehoused and it never saw the light of the day. But for the lawmakers, the law is settled. The Supreme Court has settled that one finally, that once you defect from your political party,
yes, that's
provisions of the Section 68 and 109, once you leave your political party, those votes, you stand to lose that seat, except you can show that what led to that your defection is a division or an amalgamation between your party and the party you went to.
Very quickly now, very quickly.
Quickly, in the Supreme Court, in the case of Abegunde, now decided what division in the party means, that there must be a division at the national office of the party that will likely split the party into 2. So in the case of the lawmakers, there is no division in PDP. It is obvious at the division at the center, of PDP that will determine their defective.
And in the case of those lawmakers,
there is no law.
And in the case of the lawmakers, the law says a by-election has to be conducted to fill their seats. It's not as if it's not as if their votes will now be transferred to the other party. I mean, to the candidates of other political parties.
Candidates. No, not at all. Section 140 forbids that, of the Electoral Act forbids that.
Now, one of the reasons I asked you that question is very simple, because I've had this argument, and just as you have said, that the court has said, and of course, which the judge in this case actually relied on, saying that the votes from any election exclusively belongs to the political party and not the candidate. So my question is this: if that is actually the case, that the votes belong to the political party and not the candidate, then why then the political parties should actually feel free to do whatever they want with their votes. As a matter of fact, why then does the law require that for a political party to take part in an election, the political party will have to field the candidate? I mean, just the same way until this latest amendment that we've had now on independent candidacy, if you want to run for an election, you actually need to come under the platform of a political party. And a political party on its own can actually not go contest an election by its name without using a candidate. So I'm just trying to reconcile that when the court says the votes belong to the political parties, Because if that is the case, then the political parties should be free to do whatever they want with their votes. If, for instance, a political party has a problem with a particular governor, for instance, maybe there's a disagreement and the political party accuses that governor of anti-party activity, then the political party can actually expel the governor, then collect the votes, and then give the votes to someone else.
No. You see, these are rules to guard against one party robbing the other party.
But there's something wrong with that.
No. The same way a political party cannot, whose candidate have stood for election, even though it is the party's name and the logo that is on the ballot, the same way the party cannot deprive or deny the candidate of the benefit of that victory, it is also the same way a candidate should not, even though it is not in our law, a candidate should not be allowed to deprive and deny a party of the victory of an election. So it should go pari passu. So the court, in its wisdom, had consistently maintained that, yes, what it means that these votes, because the party is what is recognized, the candidates is holding those votes in trust for the party. And it is not for the party to do whatever it wishes with it. Because if you do that, what it means, the party can use people and at the end of the day, dump them. And that is why also the court in its wisdom had also, to add to that, the court in its wisdom had said that you can, once a party nominates a candidate, the party can no longer substitute that candidate except on the ground of death.
Now, so Libos, the reason I'm asking you, sorry to cut you, the reason I'm asking you this is because on the basis of the judgment of this Justice Inyang Ekwu, it's very clear. It's very clear that that is the way he interprets that court pronouncement. And that's the reason why he said, look, take the INEC, receive the names that the PDP gives you, and then just go ahead and issue certificate of returns to them and swear them in. Or in the alternative, you organize, you conduct an election.
No, that is why I'm also telling you that is not the position of the law. The position of the law, even though the court had admitted, but let me even use the everyday man's, the layman's language. If you read a cumulative reading of all the sections of the Constitution vis-a-vis the Electoral Act and the court judgment, one cannot validly say that all of the vote belongs to the party. The party has a stake in the vote the same way the candidate has a stake in the vote. Do you know why? That is why I explained to you now that Section 140, for example, you cannot, even though the court had said votes belong to the party, but the party cannot do anything with those votes. Once the candidate defects, there will have to be another election. You can't do anything with it. And then also, secondly, once a candidate is validly nominated, that candidate can no longer be substituted. That these are provisions of the law to ensure that the vote, the candidate is not only protected and insulated from the antics of the political party, but the vote is also secured for against the in favor of the party, so that the candidate cannot do whatever he likes with those votes. So it goes together. So I think it is the layman's way of saying it to say, yeah, the vote belongs to the party and the party can do whatever he wants with it. That is not the position of the law. That is why that pronouncement of Justice Ekwo cannot stand the test of legal jurisprudence, because you can't ask the candidate, okay, how is the party going to produce another candidate now? Are they going to conduct a by-election, another primaries?
They've actually gone ahead to announce names. They've gone ahead to announce names anyway.
That's what I am saying. And there are provisions for nominating candidates. And how do you nominate that candidate? Was it through a primaries? Was the candidate produced through a primary? Is the time for conducting primaries? Is it now the time for conducting? Is now the time for conducting primaries to fill in a vacant position? So that is why I told you that it is not as easy as the pronouncement of the judge. There are other legal hurdles that are put in place to ensure that even though we say the vote belongs to the party, the vote also are secure for the candidate.
I'm afraid we just have to leave it there. Thank you so very much for this very, very deep insight into this confusing legal verdict. Now, thank you very much for your time. I really appreciate this. Thanks a lot. All right, we'll take a short break and we'll be right back. Stay with us. Welcome back. Now let's continue the discussion now on that court judgment now on Governor Umahi and its implication. I'm now being joined on the program by another legal practitioner, Oluwole Kehinde. Mr. Kehinde, thank you very much for joining us on the program. First off, let me get your take on the verdict of the court.
Well,
Yes, I want to get your verdict now. I want to get your own take on the verdict of that court.
Yeah, I think the court went too far by declaring that the governor should cease to hold office or should vacate office. One thing is that the governor decamped by petitioning the party that brought him to power. But I think there is a lacuna in the law, because the law as it is today, which stipulates that an elected person will lose his seat by reason of the petitioning the political party that brings him to power, is in respect of members of the legislature. It does not relate to governors. To that extent, the court exercises a jurisdiction it does not have. From the provisions of the Constitution, it is only election tribunal that can decide that a governor, a person occupying the position of a governor, should vacate the office and should cease to be a governor and then be removed. Outside that, the other forum or channels is through impeachment under Section 188 of the Constitution, or by the Executive Council under Section 189, if the governor becomes incapable of discharging the duties of the office.
Exactly.
We are aware of previous decisions of the court, especially the Supreme Court, in Amechi and INEC, where the Supreme Court, in the course of exercising its disciplinary jurisdiction, held that when election was held in Rivers State with a different name on the ballot paper, that the electorate actually voted for PDP and not the name different from that of Amici. Now, we all know that the Supreme Court was trying to exercise its disciplinary jurisdiction at that time because PDP tried to outsmart the court by making sure that Amici's name did not reflect on the ballot paper. That is excluding him. But the Electoral Act has since been amended in 2010.
Exactly.
Yes, under Section 140 now, there's no way anybody, the election tribunal cannot declare anybody winner of an election he did not participate in. So this case now, to now say that a high court will remove a governor because the governor has abandoned the political party that brought him to power is going too far. And also, previously, before now, in Igige, Achuku, When they said they raised the issue of the swearing to an oath and they went to High Court to get an order removing him that he had resigned. The same thing the court held, that the High Court cannot remove a governor. If the governor has been elected, it's either through election tribunal or impeachment, or by declaration by the Executive Council that the governor can no longer exercise the function of the office. The same thing happened in Kogi State, in Ejura against INEC. The court held, applying the same principle in the case of Ngige, that the High Court cannot remove the governor. So I believe that all that the court ought to have said in this case is that the governor was wrong to have abandoned the political party that brought him to power and make a declaration that he's no longer the candidate of that party. If the court does that, then it should be left for the State House Assembly to activate the process of impeaching the governor. That is no longer the governor. Is no longer the candidate of the party that brought him power. Of course.
Now let me quickly ask you this. Now let me quickly ask you this, and I want your take on it. Look, before this court gave its judgment, we saw a similar judgment by a high court in Zamfara State. I mean, we have a similar case in Zamfara State. A federal high court actually gave its ruling in Zamfara State, basically saying that, of course, just as you have said, that it doesn't have the jurisdiction, that the governor cannot be removed, that the governor, even though the governor has defected, he cannot be removed. So that judgment, of course, in favor of the governor. But surprisingly, this is another federal high court giving judgment on a similar case. And, you know, let's even take this further. Even before now, a state high court in Abakaliki had actually also adjudicated on this case and ruled in favor of the governor. And then you have another federal high court now, and these are supposed to be courts of coordinate jurisdiction. Should this case have even come up in the federal high court in Abuja in the first place? Because as we speak now, even with that of Zamfara, we understand there's another case also before this federal high court judge in Abuja on the same Zamfara as well. And he's fixed April 8 for ruling. So, you know, what do you make of all of this seeming confusion? You know, courts of coordinate jurisdiction hearing the same case and coming out with different positions.
Yes, it's a tragedy. It's an unfortunate situation that the legal profession, the judiciary, and the public at large have been bearing with for a long time. And the courts in several cases have held that these are not supposed to be. Remember recently the election that took place in Anambra. Some orders were granted in Kano, some in Sokoto, some Abuja, whereas the contest was to be in Anambra State. So it's a problem we keep on having. The problem we have is that there are different ways by which lawyers try to ascribe jurisdiction to courts, particularly when it has to do with territorial jurisdiction. I want to believe that they went to Abuja by making the parties, the principal parties in this case, especially PDP, INEC, or APC, maybe they were made parties. And we know that their principal offices are in Abuja. Then they now make the governor to be a nominal party, or so to be. So the court in Abuja will look at it and that's.
But the question is when a court is giving judgment on a case, is it not supposed to make for instance, a reference to a judgment on a similar case given by another court, especially court of coordinate jurisdiction, is it not even supposed to take notice of what has transpired in a court of coordinate jurisdiction in hearing a particular case, especially when that case has been heard by another court of the same status in another place?
Well, I think it is a complex issue. Ordinarily, it's supposed to be, but the judge may pretend not to be aware of the previous decision. Because ordinarily, except for cases of the superior courts that are regularly reported and cited, the judgment of the court of coordinate jurisdiction will have to be brought to the attention of the judge in the present case. And the only way you can bring it to the attention of that judge is by exhibiting or submitting a certified true copy of that judgment, not what people are reading in the newspapers or social media. For the court to take cognizance of that judgment, there will be a certified true copy. Ordinarily, when you are talking of the federal court, the judgment of every division of the federal court, of every justice of that court, should be available to every other judge. But even in the court of appeal, we have conflicting decisions. Court of appeal, that is the appellate court, you will have a decision in Port Harcourt contradicting another decision in Ilorin.
Exactly.
So if that could happen at the court of appeal, what do we expect even at the level of the federal court? I say it is complex because some judges may decide that they are not aware. Of course, they are aware in the public, but on the bench, they are not aware. That is one. Two, and with due difference to them, they are entitled to distinguish sometimes. Even decisions of Supreme Court, they may say, oh, this is the decision of Supreme Court, but the facts are not the same. The issues are not the same. They are not exactly the same. So they may use that channel to avoid the existing decision. Then sometimes the law itself is dynamic. The judge that just gave this judgment may feel that, oh, in that earlier case, they did not really deal with one particular point. Now, that point is available here, and it has been well argued. Now, I am going to rely on that point. But sincerely, I cannot see any new point in this, because what seems to be the dominant factor here is for the court to say he rode on back of PDP. So having jurisdiction PDP, he has no platform to stand on. But the law has since changed. The Supreme Court gave that in Amichi's case, but the Electoral Act has since amended that.
Yes, exactly.
Yes. And then apart from that, there are previous decisions of the Court of Appeal, like I said, in Ligigi and Achuku and Ejua and Idris, where the appellate court heard that a high court does not, a high court can declare, I agree, that based on this and this, you are no longer the governor. You are no longer holding the office of the governor. Your tenure has ceased, all those things. But then to declare that that governor should vacate and is hereby removed, that power does not lie in the governor. It's either an election tribunal or an executive council where a governor is incapable of performing the office of the governor, or the House of Assembly in the case of impeachment.
All right. Okay. I think we'll just have to leave it there. Thank you very much, Mr.
Thank you so much.
Thank you very much for your time.
My
and
pleasure.
Thank you for joining us. Yeah.
Thank you.
All right. That's how much we can take on the program this week. We thank you very much for watching. I'll see you again next week. Bye-bye.